Hi, everyone, and welcome to today's webinar. My name is Anna, and I'm with the New Mexico Small Business Development Center. Today, we have Natalia Hernandez joining us, who is a seasoned human resources professional. Natalia holds a Master's of Law degree with a concentration in labor and employment law, and currently works in conjunction with a team of lawyers to help businesses that are dealing with employee issues. She also works with clients to develop customized policies and procedures for their individual businesses. Natalia will be presenting Defend Your Business Against EEOC and Department of Workforce Solution Complaints. And then Natalia, if you wouldn't mind progressing to the next slide. Awesome, thank you so much. This current slide features some COVID-19 business resource links, which I won't go over in detail now, as we'll send you a copy of today's presentation via email after the webinar, so no need to write this information down. And then moving on to the next slide, we will be using the Q&A function to take questions and welcome attendee participation, so don't hesitate to ask us any questions you may have. We'll answer those questions during and at the end of the webinar. Remember to put that into the Q&A function. Please visit our website at nmsbdc.org to view our upcoming no-cost webinars or to sign up for our no-cost counseling services. I will also send a follow-up email to you with this information, and I'll send it to you via chat as well. Thanks so much for joining us. And without further ado, I will hand it over to you, Natalia.
Hi, everyone. I hope you're having a great day. So today's presentation is going to address training offerings and counseling assistance, training objectives, and EEOC and Department of Workforce Solution defenses, general information, questions, and next steps. So the first two were covered by our lovely host, Anna, and I'm going to progress to the bottom. Here's the training and offering counseling assistant trainings that are offered. Again, please go to the website. Do you need to add anything, Anna?
No, we're all good. I'll chat through that website link here shortly. Thank you so much, Natalia.
Great. Okay, training objectives. This is what we're going to be talking about today. So to fully understand the EEOC process of dealing with charges, we'll talk about discrimination and COVID-19 impact, because that's the hot topic right now. We'll talk about understanding the Department of Workforce Solutions, and then last but not least, how to deal with charges and how to understand kind of what's happening to you. Disclaimer, we are a law firm. I do not represent you. While I can provide legal advice, New Mexico's Small Business Development Center is not a law firm and cannot give legal advice. Therefore, the material presented in this presentation should be viewed as general advice and not legal advice. Okay. Here are some of the best practices that I have pulled off of the EEOC website for employers and, of course, HR. Training. We cannot say this enough. Train your managers, train HR. Make sure that people, when they deal with a manager in your company, when they deal with anybody who is their superior, make sure that that person has some kind of people training, right? Make sure that they really understand what the EEOC is, Title VII, of course, discrimination, talk about all of those things, make sure that they get training. Number two, promote inclusive culture. I know you guys hear this pretty often. D&I, culture, those are all kind of things that are kind of thrown at us nowadays. But really and truly, think about it as your culture at work. What should that be? And that should be respect and professionalism, because we all know that that goes a long way. Think about the please and the thank you and human civility. It's just the very basics, and it will help to promote that kind of culture that's not only inclusive, but respectful. Number three is open communication. Talking, listening, and clarification are key. So talk, just talk. Think about it in the respects of communicating downward and then communicating back upward. What does that look like? When you talk to staff, are you talking about who, what, where, when, why? Are you really giving them that why? Because most of the time I find that when people know why, then it gives them purpose. It helps them to better understand where you're going with this. And summarize. So again, just try to clarify, hey, did you understand what I just said? Here's kind of a summary of what I did say. And I often will encourage people to use emails to send clarification, especially if we're talking about anything that needs to be documented. And this is kind of going off into the HR realm of it, but like performance, pay, reviews, anything like that should be communicated in email so you have documentation. Number 4, remain unbiased when making decisions, and that's all decisions. Think about hiring decisions, employment conditions, promotions. So in promotions, especially in small businesses, you want to make sure that you're doing your due diligence and that you're not being biased in this process. Make sure that you're talking to somebody to identify, hey, I'm promoting this person because X, Y, and Z. And it kind of helps to talk it out, whether it's your HR professional, a co-owner, somebody like myself who does consultant work. These are part of the things that I talk about with my clients as well. And last but not least, which is not part of the best practices for EEOC, but I thought that this should be part of this list. You should identify who's going to be responding to any discrimination charges, because often this is when an attorney is brought on and partners with HR/managers/owners. Depending on your HR professional, they may or may not be comfortable responding to charges. Maybe it's with the EEOC and maybe they have experience in it or not. Make sure that you're having that conversation. Make sure that you know whoever is in charge of this knows what they're doing and has experience. It is vital. Okay, next slide. Documentation is important. So again, this is the whole HR side of me. I will say documentation forms, just keep this in the back of your mind always. Email, written notes, reports, handbook, policies, performance reviews, corrective action, performance reviews, again, and I emphasize that for a specific reason. Performance reviews sometimes are 60, 90 days, and then other times you have the annual reviews. Some companies have mid-year checks, some have quarterly check-ins. Just make sure that whatever you are doing, please make sure to keep those on file. Which leads me into confirm that your business will have what it would need in case charges are filed. Prepare for the worst, hope for the best. Who is handling your employee files and are they properly managed? Is the documentation being preserved? I could go down the spoliation realm and not getting rid of what you do have, because you're supposed to be forward thinking and know when you're going to be sued or just in case you may be sued. But regardless, keep any documentation that you feel would be necessary to defend yourself. And there's different timeframes for disposing of certain files. As a thumb, just thumb rule, 7 years at minimum for me. And that's just what I always will start off with is 7 years. If I keep everything for 7 years, I think I'm going to be covered. Now, charges, I could go into, some of them have to be filed within 180 days. Some are 300 days. That just depends. But if you think, hey, a year minimum, would that be enough? Yes, no, maybe so. But I always say 7 years just to kind of cover the ground basis. Okay, what can you expect after a charge is filed with the EEOC? You will get notification of the charge. So a charge is filed, and then you will get notified within 10 days. I like to say 10 business days because it usually happens that way. I will also say that they're usually fairly quick about it. So when a charge is filed, they're very good about getting it right out. Please remember that a charge does not constitute a finding that your organization has engaged in discrimination, okay? Always keep that in the forefront of your mind, because you'll get the charge, you're going to read through it, and most people are upset, right? Because these are your personal businesses, small businesses, and some people feel attacked, right? Read the charges, get with your HR professional, get with your attorney, whomever is helping you through this. Make sure that you, again, remind yourself, this does not constitute a finding that you have done any wrong, okay? Mediation or settlement. What can oftentimes happen is not only will the EEOC kind of start their portion of their investigation, they will encourage mediation, and oftentimes it results in a settlement. When they're starting the investigation, this is kind of, they're constructing what they need. They're constructing checklists and what documents they're going to need. You'll probably get a request for a position statement. But first and foremost, you want to think about, if I go down mediation path, will this stop it right here? And then I don't have to spend lots of money or time to respond to this position. Think about it, decide what's best for you. Sometimes during these sessions, people will then realize that there has been a miscommunication, or maybe the employee received messaging differently than it was intended to be. There's lots of things that could happen during that time frame. I sincerely encourage everybody to attempt mediation before any of this goes down that further path. I see that there's 2 chats, Anna. Do I need to stop?
No, you're good. Those are just my chats with some information.
Okay.
And remember, if you have any questions, be sure to put them into the Q&A, and please don't be shy. We encourage questions. So thanks so much, Natalia.
Thank you. So next slide. Again, this is continued after the charge is filed. The investigation. The investigator's evaluation of the information submitted to them will lead to a recommendation based on reasonable cause that unlawful discrimination has occurred or not. Okay, so a finding or not a finding. So is there reasonable cause for them to believe that there was wrongdoing? Okay, if yes, then the investigation is going to proceed. If no, oftentimes the investigation will just be closed. They'll encourage you again to do some form of like mediation. Now, if the investigation proceeds, you're going to get requests for information and a statement of position. So this is your response to this charge. Remember to always respond promptly and completely. More is better, so you want to produce all of the evidence in the first response. Make sure that you are giving all of the evidence, talking to attorneys here in-house and other HR professionals. You will find that there are times that maybe a piece of evidence was missed, or maybe the supervisor wasn't spoken to before that first response is made. It is imperative that you get all of the evidence and everything into the first response, because you may not be allowed to provide it later. Policies, handbook, personnel files, / other relevant information. Be aware that they could potentially want to conduct an on-site visit and speak to witnesses and conduct interviews. So those are all things that could potentially happen. I have had this happen. So it's pretty easy and it's pretty clear, but I will say that because this is a charge that you've received, you will again feel a little bit protective of your business, of what's going on. So again, just think this is a charge, they're doing an investigation and you're complying. Think of it that way. The investigation results, okay? So if there is not a reasonable cause to believe that discrimination has occurred, the charging party will be issued a notice called a dismissal and notice of rights, okay? This notice informs the charging party that he or she has the right to file a lawsuit in federal court within 90 days from the date of its receipt. You, the respondent, will also get a copy of this notice. If there is reasonable cause to believe discrimination has occurred, both parties will be sent a letter that is going to be their determination. There will be a reason as to why they believe that the discrimination occurred, and it will be inviting the parties to join the agency in seeking to resolve the charge through an informal process known as conciliation. So again, this is about coming together and trying to solve this without having to go before a judge. When conciliation fails to resolve the charge, the EEOC has the authority to enforce violations of its statutes by filing a lawsuit in federal court. However, if the EEOC decides not to litigate, the charging party will then again get their notice of right to sue and may file a lawsuit in federal court within 90 days. But if the EEOC does not choose to litigate it, it's then the complainant has to go and file this, right? Types of discrimination. And maybe I should stop. Does anybody have questions about what I just spoke about with results, with anything else?
Again, don't be shy to ask questions. I definitely don't see any at the moment, Natalia. I'll be sure to let you know if I see anything pop up.
Great, thanks. Types of discrimination. I'm sure that anybody who is on this has heard all of these. They're often called Title VII. Things that you want to just take a brief overview again is age. You want to think about disability. And for age, it's anything over 40. I will say that there's been an uptick in people filing complaints about ageism, particularly if somebody is really young and their early career, they don't have the experience that they need, or hey, you're too young for this kind of a role. Like that also falls into something somewhere else. And just so that you're aware, that's still not something that should be happening, but often it does. And then equal pay compensation, genetic information, harassment, national origin, race/color, pregnancy, religion, retaliation, sex, sexual harassment, sexual orientation, or gender identity. So if anybody has questions about this, there is a list, and I have included the link to EEOC site that will go into each one of these in a very high touch level. So it will show every little detail. And I believe in some instances it does provide either like a case example or speak to why this could potentially happen. Hot topic. Everybody right now is talking about this. COVID-19 reasonable accommodation. So government employees have been mandated that they have to have the shot. And then there's medical workers that have also been mandated to have the shot. What I will say is that they do still need to offer reasonable accommodations. There is 2 right now: medical reasonable accommodations, which is usually based on existing conditions, most often pregnancy, heart conditions, something to that avail. Religious reasonable accommodations are sincerely held religious beliefs. This is another hot topic, specifically within the COVID area. What is a sincerely held belief? How does that work for the business if they're a government contractor, or if they are working with a healthcare facility, something to that? Keep in mind, both of these are still reasonable accommodations. And so it is just that. Don't allow the COVID-19 portion to complicate a simple request. Treat it just like any other accommodation. And additionally, I want you to keep in the back of, well, actually, keep this in the forefront of your mind, that objections to COVID-19 vaccinations that are based on social, political, or personal preferences or non-religious concerns about possible side effects of the vaccine do not qualify as religious beliefs under Title VII, okay? So this is something else for you to really think about. And again, this is usually when people will engage myself or an attorney because they need to know and understand what this looks like. But again, it is a simple, reasonable accommodation request. And we'll talk about this a little bit more. Reasonable accommodations, right? What does reasonable really mean? A reasonable accommodation is any change in the work environment or in the way things are usually done to help a person with a disability apply for a job, perform the duties of the job, or enjoy the benefits and privileges of employment. Most people are bringing up undue hardship. Like, what does that look like? How can I prove that this is going to break the bank? How can I prove that this is just going to not work for my company? So again, this just brings it down to significant difficulty or expense. That's what an undue hardship is. So think about the size of your business. Think about what it would cost to accommodate this person, okay? So this refers not only to financial difficulty, but to reasonable accommodations that are excessively extensive or disruptive, or those that would fundamentally alter the nature or operation of that business. That's a mouthful. But if you really take it apart and think about it, if someone is requesting, I'll take an example that I came across. Bigger corporation, there was an employee that was blind and was requesting some kind of software to be able to read screens because, you know, obviously they're blind. So this person would use software that would communicate to them what was on the screen, and then there would be a small delay, and then whomever called in would then hear what that person is asking. Again, the software, I will say, cost more than that person's salary. We have to keep into account that there was not just a small delay, but in some instances a significant one. And this specifically had call times associated with it. And so when you take all of that into account, it was an undue hardship for that business. I hope that helps. With every request for reasonable accommodation, they should be evaluated separately to determine if it would impose an undue hardship to the business, considering these items: nature and cost, the overall financial resources of your business, the effects on expenses and resources of the business, the impact of the accommodation on the business. So these are all things for you to take into consideration when you are reviewing requests for accommodation, okay? Does anybody have any questions on that before I move on? Because I know that that was a lot. Okay.
Yeah, I don't see any questions right now.
Thanks again.
Yeah.
So we'll go into Department of Workforce Solutions discrimination charges. It is very similar to the EEOC process. There are a few little quirks to it that I will speak to. So charge of discrimination is filed within 300 days of the most recent alleged act. The notice is sent to you. Mediation is encouraged, and that's actually like something that they put forth. They really do encourage it. With the mediation, of course, a closed case after the resolution, or Bureau will continue with the investigation. Again, the investigation portion, you will get a questionnaire asking for position statement information and documentation regarding the allegations. You need to comply within 20 days. Remember to always, and I cannot emphasize this enough, I wanted to like bold it and highlight it, but remember to always respond promptly and completely. More is more. Produce all of the evidence in the first response. I will say that this is a little bit different than the EEOC. This, in fact, will then bar you from introducing further evidence later on, which can affect any appeal from that decision. So again, completely, promptly review the case. You may, again, have an HR professional, an attorney. Make sure that you're providing everything that you need to defend yourself up front. Okay, cannot emphasize that enough. Charging parties will receive the position statement, and then they have 20 days to rebut. Okay, so now we're at a little over 40 days, considering when the charge came in, how long it took them to send this out to you, but you had 20 days to turn this around, and now the charging party has additional 20 days. So just keep this in mind. The evaluation of the case, possible gathering of more info, the site visits, witness interviews, again, similar to the EEOC, that could occur, that will occur based on the process that they go over. Okay. The investigator then provides a summary and a case file to their division director. The determination. The division director will review the case and decide if there is probable cause or no probable cause. Probable cause means that there is enough evidence to show that the law was broken. Both parties will be invited to conciliate the case, or both parties will be scheduled for a hearing in front of a panel of New Mexico Human Rights Commissioners or the Bureau's administrative law judge. If there's no probable cause, which means that the director did not believe there was sufficient evidence to show that the law was broken, the case will be closed, a right to sue notice will be issued, which allows the claimant to appeal that determination within 90 days by filing in district court. So very, very similar processes. Workforce Solutions is a little bit more lengthy because there's those days in between. So just things to be aware of. Here's the processes in general. Make sure that you are responding promptly, completely, that somebody else is taking a look at your response before you submit it, because you may not be able to bring up other evidence later on. Okay. I know that we're at the Q&A section. It is a bit early, so I do want to go back and take the time to review anything if necessary.
Yeah, again, don't be shy to ask questions. We love questions around here, so feel free to let us know if anything is confusing to you or if you'd like Natalia to go over a section of anything. And then Natalia, is there anything that you might want to go over in a little bit more detail, perhaps some of the descriptions of discrimination or some of those topics there?
Yeah, I
or-
can definitely go over that. Let me just go in and pull this up. Oh, actually, I'm going to hit escape on this because I do have links in here that I tried to put through and then like just notes to remind me. So let's see here. Here it is. Discrimination type, and then I added the updated technical assistance. But this top one is really the one that I referred to and that I've always referred to because it's helpful. Sorry, I have to move some things around here. Okay, so age discrimination. Again, I spoke about it being discrimination for someone over the age of 40. It talks about work situations, different kinds of harassment, which can include offensive or derogatory remarks about a person's age. The law doesn't prohibit simple teasing or offhand comments or isolated incidents that are not very serious. Again, these are subjective words, so you want to talk about what is very serious, right? Harassment is illegal when it is so frequent or severe that it creates a hostile or offensive work environment, or when it results in an adverse employment decision, such as the victim being fired or demoted. So again, this ties into the previous thought of you need to always think about those type of decisions for promoting, demoting, hiring. Make sure that those types of bias are not there. You have to try to be as unbiased as possible. Let's see. Let's move on to the other one. Disability. I think this is the one that people are most the most educated about. Discrimination occurs when an employer or other entity covered by the ADA as amended or the Rehabilitation Act has amended treats a disqualified individual who is an employee or applicant unfavorably because he or she has a disability. People often think that this just means that you see somebody in a wheelchair or you see somebody walking different, something that is visible and obvious. People also need to take into consideration that there could also be the mental component to this. You want to think about, so for instance, if somebody has a hard time maybe writing things out, do they have dyslexia? Is this something that can be controlled with medicine? Will this impact that role? Think about all of these types of decisions, and you can offer some form of assistance, so an accommodation for them. These are things to, again, to be reviewed and to really think about before any action is taken. And then here's another favorite one, is equal pay and compensation. Think about this as like pay bands. Okay, so pay bands help protect you because you have a set amount of pay, and then you have, like, let's just say you have an HR person type 1 an HR person type 2, and then 3 and 4. Okay, so if you break it down into those 4, you then should have qualifications for getting to each level, and what that pay band is, it could be according to experience or education or both. So what this creates for most people is something that is tangible, and it doesn't say, oh, well, this person is a minority, so I'm going to pay them more so people realize that I appreciate minorities more. Or the one that I get probably the most is female. I'm not being paid the same as my male counterparts. I have just as much education. I have just as much qualifications as they do. Why am I being compensated different? Oftentimes, I will say that that really gets companies sued. I have yet to see something where there's actually a pay discrepancy found where it's a pattern and there's no way for us to explain it, and then that business is sued. So these are all very important things to keep in mind. The next one is genetic information. I will say that this one hasn't come up very often. This speaks to Title II of GINA. And I will say that GINA is the Genetic Information Non-Discrimination Act of 2008, which prohibits genetic information discrimination in employment. This became effective November 21st of 2009. This prohibits use of genetic information in making employment decision, restricts employers and other entities covered by Title II. So employment agencies, labor organizations, joint labor management training, apprenticeship programs, from requesting, requiring, or purchasing genetic information, and strictly limits the disclosure of genetic information. The EEOC enforces Title II of GINA, dealing with genetic discrimination in employment. The Department of Labor, Health and Human Services, as well as the Treasury Department, have responsibility for issuing regulations for Title I of GINA, which addresses the use of genetic information in health insurance. Where I think this could become an issue is, for instance, if a workplace has a free clinic that employees can go to. So at one of my previous roles, there was a facility on site. It was like a quick type urgent care. They could do quick patches, if someone's bleeding or cut themselves, which is not workers' comp. We send them off if it happened during working hours. But I will use myself as an example. I have trouble breathing when I get upper respiratory infections, and me being stubborn a couple of times resulted in me getting walking pneumonia. And while I stayed home for, X amount of time, when I returned, I was still having that trouble breathing because I was walking around a lot. And I was able to go to that place, and they were giving me breathing treatments here and there. And so that was something that helped me stay at work so I didn't have to miss work. That is where, if blood work is then drawn, if anything else can occur, think HIPAA, genetic information, and then also for employers who have like health programs that require you to do blood work or report weight and vitals. Those are things also that, it could result in you getting some form of genetic information when there's blood work involved. So these are all things that don't really come up that I've seen here in New Mexico, but at corporations that I've worked at, it has come up. Let me go back. Harassment. This is another well-known one. Harassment is a form of employment discrimination that violates Title VII of the Civil Rights Act of 1964, the Age Discrimination and Employment Act of 1967, and the Americans with Disabilities Act of 1990. Harassment is unwelcomed conduct that is based on race, color, religion, sex, including sexual orientation, gender identity or pregnancy, national origin, older age beginning at age 40, disability or genetic information, including family medical history. Harassment becomes unlawful where one, enduring the offensive conduct becomes a condition of continued employment. So this person is forced to endure some kind of offensive conduct or behavior, which is a condition of their employment. Suck it up. This is just part of the job. Have thicker skin. Those are comments that I've heard before. And then, or two, the conduct is severe or pervasive enough to create a work environment that a reasonable person would consider intimidating, hostile, or abusive. So this is where things come into play that people throw around: hostile working environment, because of maybe bullying or because of the conditions that they work under, if that makes sense. I see a chat on it. Is that a question?
That's just me. I chatted through just to let you know. Yeah, I'm constantly chatting stuff through, but I did chat through the link to our YouTube page where you can view previous webinars of ours, and then some additional resources for you. I will also email those to you, so no need to write those down. And sometimes the links in these chats don't actively work, so my apologies if that's not working right now. Again, I will email that to you. And then Natalia, I'll let you continue.
Links are in the slides too, so when you send out the slides, that'll be helpful. Let's see. So we talked about the harassment portion, which includes, the national origin, race, color, pregnancy, religion, and then we can go on to retaliation real quick. Okay, the EEO laws prohibit punishing job applicants or employees for asserting their rights to be free from employment discrimination, including harassment. Asserting these EEO rights is called protected activity, and it can take many forms. For example, it's unlawful to retaliate against applicants or employees for filing or being a witness in an EEO charge, complaint, investigation, or lawsuit. Communicating with a supervisor or manager about employment discrimination, including harassment. Answering questions during an employee investigation of alleged harassment. Refusing to follow orders that would result in discrimination, resisting sexual advances or intervening to protect others, requesting accommodation of a disability or for a religious practice, asking managers or coworkers about salary information to uncover potentially discriminatory wages. So those are all examples of what retaliation could be. I will say that this is often just titled as an adverse reaction to, and then you can adopt sexual advances, harassment, communication, complying with any investigation. Sex, sexual harassment, sexual orientation, those are completely covered. Just think about it as if, so sexual harassment is the unwanted behavior. Okay, sex discrimination is based on being female, male. The males get more leeway versus the females, and then that ties back into like pay equality oftentimes. So you want to think about those differences. Take a look at the links as well, because it will help you get into it a little bit further. So sex that is based on, or I'm sorry, discrimination that is based on sex. The sexual harassment, again, speaks to those type of behaviors. So it's unwanted sexual advances, requests for sexual favors, and or other verbal or physical harassment of a sexual nature. Last but not least, sexual orientation and gender identity. I've seen an uptick in these complaints, and this is probably what people have seen, where it has, I believe, on LinkedIn, what that person has identified as she, her, or him, he. So those are some indicators that will allow people to be able to speak to you like they speak to everybody else and refer back to you to the sexual orientation that you prefer. And this goes a little bit lengthier because of the gender identity, and to fully explain what that looks like, there's a whole paragraph in here that I encourage all of you to read. But those are just types of discrimination, and please take a look at the link. I cannot say that enough. If you don't understand any of these, please take a look at it. And again, this ties back into training to make sure that your company is protected. No questions?
Yeah, we don't have any questions, so we can just wrap this up at this stage.
Okay.
Thank you all again for your attendance, and Natalia, thank you so much for the presentation. Super informative, very helpful. Appreciate it so much. And yeah, just don't forget to visit our website at nmsbdc.org to view our upcoming no-cost webinars or to sign up for our no-cost counseling services. We are here to help you during any stage of your business, so don't hesitate to reach out to us. And yeah, thank you again for your attendance. And I will go ahead and stop the recording and dismiss the remaining attendees.